Hello, I'm Karen Long, President and founder of Streamline Government Contracts. Streamline helps small to mid-sized government contractors who seek experienced, effective support with contract management that will help reduce risks, increase profits, and enhance your reputation. We do this by negotiating teaming agreements, subcontracts, preparing estimates at completion, and communicating with the contracting officer in their own language. We are the proud sponsors of Government Contractor Chat. We appreciate you joining us today.
Thank you, Karen. Hello, everyone. My name is Lindsay Riegelsberger. I am the Operations Manager and Marketing Specialist for Streamline Government Contracts. I'm going to introduce our guest speaker now. Please mute yourselves and go off camera at this time. This will be an interactive discussion, so please feel free to unmute yourselves to ask questions throughout the presentation. Daniel Strouse is a government contracts attorney at Cordatis LLP. He represents contractors across a broad spectrum of issues, including bid protests, claims, counseling, small business compliance, and disputes between parties. Without further ado, let's welcome Daniel Strouse.
Thank you, Lindsay and Karen, for having me today. Thank you for everybody for being here. Today, we're going to talk about bid protests, and I'm Daniel Strouse with the law firm Cordatis LLP. So we will just dive in. The first question to talk about when we're talking about bid protests is to really explain what a bid protest is. And a bid protest can take a variety of forms, but is always a challenge to a federal agency's procurement decisions or actions. So that can come in the form of a pre-award protest where we are challenging the terms of a solicitation. We'll talk about what that means a little bit later. It can relate, obviously, to an award decision that the agency makes, or there can be something in between if the agency excludes you from the competitive range, or the agency finds that another offeror does not have a conflict of interest. We might wind up in some sort of in-between phase. But the protest process is there to take on any challenge to the federal agency's procurement decisions in a form called a bid protest. These statistics talk about GAO bid protests, which is the most common forum for handling bid protests. As you'll see, we sit somewhere around 2,000 cases per year over the last several years. Last year was a bit of an anomaly because of the CIO SP4 protest. What you see throughout here generally is that the sustain rate sits around 13 to 15%, which is a protest that GAO decides has gone from start to finish, and the GAO attorney has decided that the protester is correct. Last year, the sustain rate was significantly higher. Again, this is an anomaly due to the CIO SP4 protests, but the sustain rate typically sits somewhere around 15 to 15%. You'll see on the bottom here a slide called the effectiveness rate. And the effectiveness rate takes into account not only when GAO sustains the protest, but also when GAO or the agency take corrective action or recommend that the agency take corrective action. This doesn't necessarily mean that in 57% or 50% of protests that the protester gets the award, but it does mean that in 50% of the protests or so, the government decides that they did something improperly and that needs to be fixed. What can you protest? You can protest FAR Part 15 procurements, which is just a typical RFP. You can protest commercial item procurement, simplified acquisitions, IFBs, and as becomes more and more prominent in the world of federal procurement, you can protest task orders. However, you can only protest task orders at GAO, and if the task order is valued over $10 million for a civilian IDIQ contract or $25 million for a DoD contract. Those task order values don't apply to GSA schedule procurements. For a GSA schedule procurement, go ahead.
I'm sorry, I didn't mean to interrupt. Can you, for our audience, can you explain what IFBs are?
Sure. IFBs are a relic of the past, largely. An IFB is an information or an invitation for bids. And those bids are, unlike a proposal, those bids are open in public in front of everybody, largely to be given to the lowest bidder, the lowest price at the time. Here we won't speak very much about what an IFB is, but if you have any questions about it, feel free. It's largely unused anymore, at least in my world. It fits for occasionally a construction project or small projects along the way. And as I see people hopping on, if anybody feels like they want to ask a question along the way, speaking to people is much more fun than speaking to a bunch of blank screens. So feel free to either pop a question in the chat or hop on. Nothing I'm saying is so important it can't be interrupted. Where can you protest? You can protest with the agency, you can protest at the Court of Federal Claims, and you can protest at the Government Accountability Office. The benefits are laid out here in the slide a little bit. I typically avoid agency level protests unless we are protesting the terms of a solicitation. An agency level protest isn't public, or you don't get an opportunity to respond to what the agency has said, and your decision comes virtually from the people who have already made their award decision. But it can be effective if you want to make a point or in a pre-award context. The Court of Federal Claims is becoming an increasingly popular option for bid protests. It does not come with an automatic stay. However, it does come with what I'd call a little bit more equity than you get at GAO. There's a little bit more opportunity for argument and flexibility, and I think the court is more inclined to write longer decisions, which lends itself to a willingness to go beyond a typical soundbite the GAO protests sometimes stick with. And I think a lot of times companies feel more heard. At GAO, however, which is still, I believe, the most common forum for protests, it's less expensive than a Court of Federal Claims protest, and you get what's called an automatic stay. And the automatic stay is important because it stops the government from performing the awarded contract, or if it's a pre-award protest, from awarding the contract before we even get, so you don't lose the work while the protest is going on.
Hey, Daniel, did you say that 50% of the 50% are upheld?
No, 57% is the effectiveness rate. And what that means is GAO has either sustained the protest or at some point during the process, the agency has recognized a mistake in their solicitation or in their award decision, and they go back and take corrective action to fix that problem on their own. This doesn't necessarily mean that the protester is going to get the work. The sustain could be as simple as we realize that we improperly evaluated proposals. We need to do a reevaluation, even if it means the same result comes out. It could mean that we realized there was an error in the solicitation. We had to clarify it. So effectiveness rate does not mean that it is different than the sustain rate, and is again further different than guaranteeing the protester will win the award. Does that answer your question, Karen?
Yeah, thanks.
Beautiful. Well, what I tried to do through this presentation is kind of walk you through how I think you as a contractor will go through the process and of thinking through when, how to protest, if you need to protest from start to finish. And that starts with opening the solicitation. What are we looking for when we open the solicitation? You guys as contractors are obviously looking at what's the statement of work look like? What do we have to do? How do we price it? I am looking at what do sections L and M of the solicitation look like? Are they clear? Do they match up to the statement of work? Are there problems that will prevent me from bidding properly? So do I understand what the government is asking for? Do I understand what the page limits are? Do I understand what the instructions are? Are the instructions consistent? Does it say in one portion that past performance has to be from the prime contractor, and another portion it says past performance can be from a subcontractor? If there's an inconsistency, we need to understand what that inconsistency is and how to get the government what they're looking for, because the last thing you want to do is think the government is asking for one thing and find out after you've submitted the proposal, wind up in a situation where they were looking for something totally different. The other thing we're often looking for is whether the terms of the solicitation are restrictive. I hear from clients all of the time that they believe a solicitation is wired towards a particular entity. And the way that gets done is because the solicitation criteria, evaluation criteria, statement of work really narrow the field to say something to the effect of, we really only want Samsung monitors, but magically only Samsung can provide those monitors. And now all of the Sony people are out of luck. Is that necessary? Why do you need the Samsung monitor? We're looking to make sure that the solicitation isn't restrictive, and if it is, how we can challenge that. We're also looking for any sort of favoritism towards some offerers over others, and we're looking to make sure, almost most importantly, how price will be evaluated and whether it matches what you think is reasonable. We lose the opportunity to protest an impropriety in the solicitation if we don't protest before before proposals are submitted. And so if you think there are any sort of problems with your solicitation along the way, please reach out so we can have that discussion, because I don't want you to lose those opportunities along the way.
So, Daniel, can I share an example
I would love
of,
for you to.
I would say this goes back 20 years or so, and I will say I was an employee at that point, and so the company I worked for was the recipient and so forth. They actually, so this was for NRC, for career counseling, and and they really liked the person that we had as a career counselor on the contract, and the requirements for the qualifications for the that the government contractor would have to have were like so specific and so forth. Like, it was just really clearly they had looked at this person's resume and had taken a lot of things from it. But anyway, the result was, um like, we were expecting somebody to protest because it clearly was kind of wired for the company. But at any rate, I will say we were fortunate. It wasn't a huge contract, so maybe that's why people didn't feel like it was worth it to protest. But nevertheless, so anyway, so what I've seen and what I find suspicious, and obviously I'm not an attorney, but is to, like, when they have such an obscure skill set that they're looking for a specific labor category, especially if it's key personnel.
Yep, absolutely. No, there are all sorts of ways that one can wire a solicitation if that's the goal. I tend to not be a conspiracy theorist. I tend to think that most procurements are actually fairly and openly competed. But occasionally something slips through the cracks, and that's what we're here to prevent. We're here to basically be what I've always called a free auditor to the government, to make sure there are no problems. We are here to make sure that GAO is there to give oversight, and we are giving voice to that oversight. As you said, in a pre-award protest, the general goal is to make sure that the solicitation provides everybody with a fair opportunity. And if you don't think you have a fair opportunity, we need to go after that. On this slide, you'll see that I've listed several issues that we believe to be fairly common to a pre-award protest. The terms that are unduly restrictive of competition, ambiguous terms so you don't know how to write your proposal, terms that you don't think set forth the requirements properly, an evaluation scheme that is off base. For example, if the solicitation calls for lowest price technically acceptable, we know now that that's disfavored and that regulations largely prohibit that absent clear requirements. And so to the extent we have an evaluation scheme that's LPTA, we might want to look into that. Here are just two examples of pre-award protests where one in an agency included a requirement to possess a certain certification prior to proposal submission. However, GAO found there was no reason that you needed to have that certification prior to proposal submission. It would be okay to get that certification prior to performance, and therefore that was unduly restrictive of competition. In this other one, it's an older one now, back in 1999. It was for a fixed price solicitation that placed undue risk on offerors because there was no limitation on the work. So basically, the work could be indefinite, but offerors were being asked to put a fixed price to it, which places an undue risk on the government.
Yeah.
Here are a couple more examples that I think we can work through. Karen, I think you provide the slides to people so they can see these and pull up the protests.
Yep.
Separately.
Daniel, going back a couple of slides, you mentioned lack of clarity.
Yes, ma'am.
So would that be lack of clarity on the statement of work, on the can you expand on what you
All of
mean?
the above. Lack of clarity can come in lots of different forms. Lack of clarity could say, for example, in an IT services contract, do development work. And you're like, well, I don't really know what do development work means. Does it mean I'm doing from start to finish, I'm developing software? Does it mean I'm doing O&M? Does it mean I'm doing all of the above? We don't know what we're bidding to. So there's a lack of clarity in the statement of work. Other times there could be a lack of clarity in what you're supposed to submit to the government. Is it clear what they're looking for? Is it clear how you're supposed to submit your pricing? Is it clear what you're supposed to be pricing to? A lack of clarity can come virtually anywhere in the solicitation. Does the pricing proposal match what Schedule B looks like on the first page of the solicitation? I mean, it can come in a whole host of different ways, but we're looking for it everywhere.
So I don't know if I have another question. I don't know if this is too general or not, but I've seen a situation um, where basically in the questions and answers, someone has asked for more information in terms of like systems. If you think about IT and so forth, and I'm definitely not an IT expert to say the least, but but basically some internal knowledge that the incumbent would have, but no other vendors would have a way of getting, and the government doesn't want to provide that. Is that an unfair advantage or no?
It's
Or is
not
that too general?
it's not necessarily an unfair advantage, but again, if there's a question, if you have a question and you can't get a fair answer to the question, then you might not know how to bid. It's always fact dependent, right? If the government says we need systems and they don't specify the systems, and I'm going to bid the Mercedes of systems and you're going to bid the Toyota of systems, our systems are going to be different. And maybe the government doesn't care and the government can tell us that. And now we can each
Yeah.
price and propose accordingly. But if the government really always wanted the Mercedes and never told everybody they wanted the Mercedes, now we have a problem.
I notice I find and again your proposals you know not my core expertise, but what I find is the government doesn't always share the quantity of something that needs to be done on a firm fixed price.
Yep.
And that's sometimes what they won't share, but the incumbent has at least a better idea about that.
Yep, absolutely. Sometimes that becomes a problem, and sometimes that's okay, and sometimes it's not. That becomes fairly fact specific. So feel free to give me a call, and we can chat it out. Then the next portion of when a proposal or when a protest could arise is when we're talking about discussions and competitive range determinations. First and most important fact here is once you're moved from the competitive range, you have to ask for a debriefing immediately. The government may offer to you that you have the option to elect a post-award debriefing. This is bolded for a reason, which is you do not elect a post-award debriefing. If you do, while you may get more information in a debriefing, you will lose all of your protest rights along the way. You have to request a pre-award debriefing. The government, as we're seeing in CIOSP4, has the option on its own to give you a post-award rather than a pre-award debriefing. However, we as contractors are obligated, if given the choice, to take the pre-award debriefing because otherwise our protest would be untimely. If we're removed from the competitive range, what we're looking for is why were we removed? Did the agency evaluate our proposal fairly? And were others included in the competitive range with similar issues? when we talk about why we were removed, what we're looking for is largely, did the government do this right? Or did we have a problem that was actually removable, or did the government evaluate us wrong? And when we talk about, thanks for that question. Let me just finish this and I'll get to your question. Were others included in the competitive range with similar issues? The question popped in the chat is, what are the main valid situations to perform vid protest? I don't think I understand the question. Can you hop on audio so that I can make sure I answer you properly?
Trisha? Well, maybe we can go back to that
Sure, we'll go
after
back to
in our
that
question
after.
and answer.
When you get a competitive range debriefing, it's going to include all of the elements related to your proposal. What it won't include is what you would see in a typical post-award debriefing, in which it will talk about the other offerors, where their scores were, where their ranks were, and that makes sense because the award isn't complete yet. Without the award being complete, we won't really have an answer to what the content of other proposals are, what their ratings are. What we'll get is what your proposal looks like. You could still have issues if you're included in the competitive range. Did you learn somehow that the agency was evaluating proposals improperly? Are there ambiguities still present? We can still learn information during this process that leads to the competitive range. I apologize if you all now hear my neighbor mowing their lawn. Let's say we lose. What do we do now? First thing we have to do is we request a debriefing within 3 days. And we also want to prepare for the debriefing. We want to prepare questions, particularly now with the Department of Defense. There's a requirement that you get an opportunity to submit questions after you get the initial debriefing. You want to understand what it is that what you're looking for. What do you need to know whether you want to protest, or as significantly, what do you want to know about how your proposal was evaluated, to see if this is something that we should be fixing moving forward. Maybe you just wrote a really poor proposal. Sometimes that happens. You guys write proposals every day. And sometimes they're not as good as others, and sometimes you just need to know that. I typically like to ask for a redacted version of the source selection decision related to your work. And I want to understand and obtain as much intelligence as I possibly can. During your debriefing, you're going to learn about weaknesses, significant weaknesses, or deficiencies. You're going to learn about the overall evaluated cost, the rankings of offerors if they exist, a summary of the rationale for award, and responses to your questions. The clock starts for protesting after the debriefing is closed. We get 10 days to file a protest after the debriefing is closed. Why do we need this information? Again, we need this information because information is always king or queen. Information is the guidepost for everything that we do. It will allow us to formulate a protest if we need to. It will allow us to get our foot in the door. And again, it will allow you to understand what the government thought about your proposal.
Right.
Yeah, Garen.
So now, are there different timeframes for the type of protest and who you're going to protest to?
There are different timeframes. If you're protesting pre-award, you have to protest prior to the submission date of proposals. If you're protesting post-award under a FAR Part 15 or 16 procurement, you have to protest within 10 days after the debriefing. To get an automatic stay, you have to protest within 5 days after the debriefing, or 10 days after award, whichever is later. For a GSA schedule procurement, you actually have to protest within 10 days of when you knew or should have known about the procurement issues, because GSA schedule procurements don't require debriefings. And if you want an automatic stay, you have to protest within 10 days of the award of that delivery order. When I say within the debriefing time frame, you must accept the first debriefing date offered, or at least that is when the time period starts for the clock to tick. Your time period starts on the first date the government offers. So if the government says we're having a debriefing on February 22nd, and you say, I'm in Australia on February 22nd, I'll be home on February 23rd, the clock still starts ticking from February 22nd. I recommend when you have a debriefing, assuming that it's oral, that you have a person there whose job is to solely take notes. Not listen to what's happening, not be flexible to ask the questions you need to ask, but their job is to sit there and to completely take notes so that when you leave that room, you know you have a very detailed, factually based set of what was said and how it was said without that person having any other jobs other than to do that. I also recommend you do not have an attorney with you during your debriefing because the government does a really great job not speaking when attorneys are present. What are we Karen?
So, Daniel, so if someone loses an award on a GSA schedule, I know that the government is not required to offer them a debriefing, but will the government sometimes offer them a debriefing if they request it?
The government is required to provide what the FAR calls a brief explanation. They can provide you a debriefing if they choose to. However, that has no bearing on the clock for an automatic stay of a protest. You are entitled to protest when you knew or should have known the information. So if the government provides you a debriefing 3 weeks after award, and that's when you first learn about your information, then your protest clock starts then. However, you're not going to get an automatic stay. At that point, you may consider wanting to go to the Court of Federal Claims instead of staying at GAO. Maybe you can convince the government to give you a stay in either place, but there is no mandate at that point that you get an automatic stay, which is why what we try and do is get some sort of protest in within 10 days of the award. And what the government to tries to do frequently, in my experience, is they try to hold off that brief explanation or debriefing as long as possible, because the less information you have, the less likely it is that you're going to file a protest. I think this goes to the question that was asked in the chat, which is what are the issues that we're looking for when we're filing a bid protest? We're looking for whether the agency misevaluated your proposal, whether the agency misevaluated the awardee's proposal. Oftentimes that comes from public knowledge, that comes from past performance information, that comes from websites, that comes from whole hosts of things. But you typically, in ways I never fully understand, contractors always seem to know a lot more about their competitors than I fully grasp. We're looking to make sure that the agency evaluated proposals as they told you they would. Did the agency tell you that they were going to conduct a best value trade-off, but magically they conducted a lowest price, technically acceptable procurement? Did the agency tell you they were going to evaluate for X, but really evaluate for Y? We're also looking if there were discussions, whether the discussion questions reasonably led you to the areas of your proposal that needed to be fixed, or whether you still received a significant weakness for those problems. I'm glad that answered your question. Did the agency treat offers equally? Now that standard has changed a little bit over time, and it's become a little bit higher, but we're still wanting to make sure that the agency treated offerors fairly, and with every offeror being treated on a common basis. What we talked about earlier is the timeliness of protests. It's critical to ensure that we're timely, or we're not going to be able to be heard. We might have the best issue in the world, and GAO or a court won't listen to it. Again, timeliness differs depending on what the procurement is. If we're filing at GAO, again, it's a 10-day procurement clock typically. If we're filing at the Court of Federal Claims, there's actually no timeliness rule. However, we typically want to get in as fast as we can because we don't really want a procurement to get deeply embedded within the government procurement, and now our protest isn't really going to provide a practical benefit to you. What we want to make sure we're doing is providing a practical benefit to you. That the goal isn't just to win a pariah victory where we get a contract or we win a protest, but to make sure that at the end of the day, we get a contract. We're going to walk through the protest process. The solicitation is issued. What are we looking for? We want to ask questions if we have an opportunity. As Karen pointed to earlier, typically solicitations allow you to ask questions. If you're confused, ask. If something doesn't make sense to you, put it in a question. Now, this is not to say the government always answers these questions fairly, honestly, openly, transparently. Use your words, avoid my skepticism of the government. I apologize. Discuss your concerns with the contracting officer. Ask Karen, ask me. Hey, we really don't understand this. Is this a problem? Am I overreaching? I have no problem telling you you're overreaching. I also have no problem telling you if you're underreaching. So feel free to ask questions to us. Feel free to ask questions to Karen. Again, information is king. Asking questions is never a problem. If we don't understand what we're bidding on, how to bid it, we can't possibly be in a place to reasonably win the work. And that's the objective here. The objective from my perspective is any chance you have to avoid a protest by winning the work, the better off we'll be. Karen, did you have a question?
I just wanted to comment that you've been, very generous, and that I know I've had some clients and or companies that I know that have contacted you, and you've given them, straight advice as to whether it's worth pursuing or not. So
Thank you.
thank you for that.
I appreciate that. After we've asked questions, do we still have concerns? Did the response make it more clear? Did the response make it less clear? Oftentimes you get a response that creates an ambiguity that didn't exist before, and now you're like, well, I asked about a wage determination, and now you told me just to comply with minimum wage requirements, and those are not the same thing, and now I really don't know what to do. Or I asked a question about the statement of work, and I was talking about chairs, and now you're telling me I need stools, and chairs and stools are different things. What are we doing? Those questions can create ambiguities. If we have concerns after we've asked questions, the first question I always want to know is, does it matter, right? Yes, we're confused. Yes, we don't understand. But can we still submit a proposal? Is asking the question going to benefit you, the contractor, in your ultimate goal of getting work? And sometimes the answer is yes, and sometimes it is, man, if we ask that question, it's going to show we think we have better information than our competitors, and we don't necessarily want that field as level as the question would make it. Do the terms make it impossible to bid? I see some questions.
Yeah.
Do the terms make it impossible to bid? Legal term of art, is the evaluation scheme screwy? We will not use that legal term of art in anything official, but presentations are supposed to be fun. Is it wired a certain direction? Are there explicit acknowledgements that there's a conflict of interest? I'm just taking a quick look at the question.
Yeah. Do you want me to read it?
No, I'm taking a look. We faced a situation where we asked for a debriefing, but we have not received justifying response. In such situations, how should we respond? If your debriefing is insufficient, or your debriefing doesn't actually answer the bell to the question that you feel like you need an answer to, unfortunately, the only real path there is to file a protest. You're not really in a position to, there's no rule anywhere for court or for GAO that forces the government back into giving you a different debriefing response, and nothing that stops the timeline. So to me, if we're in a situation where the response doesn't really, debriefing questions, answers, or the debriefing itself doesn't really get you where you need to go, that's when you call me, and that's when we have a conversation about whether a protest is the right approach. And when I say me, I don't just mean me. There are lots of good versions of protest attorneys out there. I'm also always happy to make a referral. There are good people that do this. That is not just me. Nonetheless, we want to make sure that you're not losing your rights because you don't get the right answer in a debriefing. And so we still, I think, would need to go forward with a protest at that point.
But I'll add, you are very, as I'm sure our audience can see, you are very, you know, very informed and educated and good at what you do. So, and I know this is
Try to be.
um,
If I fool everybody on a daily basis, it makes my life a little bit easier. So we stick with that. We play our cards right. Now if we find an issue that we want to protest, we're still in the pre-award protest context. How can we resolve it? As I said earlier, do we want to file an agency level protest because it doesn't become public and maybe it'll make the contracting officer less upset? Is it a protest that we feel like is so significant we want to go to GAO or even to the court? I typically, if I can help it, try to avoid filing pre-award protests at court. I also consider on a fairly regular basis whether we want to file at the agency. If we think the issue is clear cut, it might make sense to go to the agency, but we talk about it. The big questions to ask here are how will the customer react, and how much is it going to cost? The lower level the protest, the less it's going to cost. And we'll talk about what your chances of success are in both the protest and the award. After awarding a contract for XYZ company, if ABC company files a bid protest, how will XYZ take necessary actions at that time? Well, let's wait till the end to talk about that. I've got a whole bunch of slides on bid protest intervention, but they're in there if that's okay. We will get to bid protest intervention, which is my baby at the moment. If we file a protest, we're going to file through the appropriate system. This slide is just for your edification. We don't really need to talk about it. Here again, for your fact sheets and checking on the backside, when are the protests due? Oh no, Ken, thank you for that question. Ken asked, what do you mean by lower level than GAO or Court of Federal Claims? There is an option, Ken, to file a protest directly with an agency. And when I say an agency, it's called an agency level protest. It's FAR Part 33.103. Don't guarantee that because I'm doing numbers from my head, but I'm pretty sure I'm right. An agency level protest goes to a level above the contracting officer where we say, hey, government, you got it wrong. I typically don't like to do this for post-award protests because it's a one-time shot. It's basically a letter that says, government, here's what you got wrong and why. But if the same people that already made the decision are looking at it, they're not likely to change their minds. However, if you're in a pre-award situation where you think there might just be a problem with the solicitation, it is a faster, more efficient, more cost efficient, more time efficient process where you can hopefully resolve your issue without having to turn this into a bigger deal than it otherwise would be. If that answered your question, Ken, you can just pop a yes into the chat, and if you need me to go deeper, I'm happy to do that also.
Yeah, thanks. I'll come off mute here. Thanks for that answer. What's the ballpark? What's the effective rate of that type of protest?
The effect of an agency level protest depends how you mean. The effect if we're filing in a post-award context, the effect of an agency level protest is that you would likely lose the automatic stay in filing a GAO protest afterwards. So if, for example, you get kicked out because the government says, I'm making up an example, the government says you only provided 2 past performance examples and the solicitation required 3. Now, past performance is weird, and I know that there's neutral ratings, but just go with my example for what popped into my head. The government kicks you out because you provided 2 instead of 3. And we know that you provided 3, it's on pages 1 through 7 of your proposal, and we file an agency level protest and say, government, you just missed it. It's sitting right there. But for some reason, the government comes back and says, nope, Ken, you filed it poorly. We're right. You were wrong. Now you're going to want to file a protest at GAO because we know we're right. Unfortunately, if we filed first with the agency, we would not get an automatic stay at GAO because the timelines between the protests wouldn't really allow for it. And so we would discuss whether the effect of filing that agency level protest is worth it or whether it's worth going to GAO. On the one hand, you'd like to think the government's going to get it right if there's something clear cut, and you can make them less angry or upset if you file directly with the agency. On the other hand, if they get it wrong, you've lost a fairly significant right. And so we talk through those. In the pre-award protest context, the benefit is nothing becomes public. You don't look like a bad apple. You don't look like a rabble rouser. And you don't really lose any rights in the process, which is why I tend to stick with it for pre-award protests if I can.
Thank you.
Yeah, absolutely. This slide kind of talks through the stay as we just talked through. I'm gonna, for the sake of time, I'm gonna go a little bit, but if you have any questions, please don't hesitate. My contact information will be here. Please don't hesitate to reach out. When we're counting days, we skip the day it happens. So if you get a debriefing on a Wednesday, the first day for counting whether it's 5 days or 10 days is really that Thursday. We also, when we're filing, want to make sure that we're filing early in the day. That's a Daniel issue, not a you issue, but I want you to know it exists. I tend to like to file early in the day just in case there are technology problems along the way. In the old days, we used to email these protests in. We now have a filing system, and that makes it better. Why are we filing a pre-award protest? Because we want to change it for the better for us, right? Hey, the scope isn't good the way it is, or it's priced really poorly. We need to fix it. And the last point here is largely for incumbents, which is, man, maybe we think that we're going to lose this follow-on contract, but if we protest, we can win another 100 days. Do I like to protest on that basis? I don't. But I think it's naive to think that clients don't like money, and I think it's naive to think that contractors don't sometimes need to game the system a little bit to get an extra 100 days. As far as I'm concerned, if we can file a viable and timely basis of protest that is not frivolous, I'm happy to have that discussion. We'll discuss whether we do it or not, but I'm happy to have that discussion. Now we're at the point where the government again gets through evaluation. We submit our proposal, sorry, not through evaluation. We submit our proposal and we get discussions. If the agency conducts discussions and we're excluded, we request our debriefing. We talked about that a little bit earlier, and we accept our pre-award or our pre-debriefing, not our post-award debriefing. Make it within 3 days. And remember that FAR Part 15 and FAR Part 16 are required debriefings, but others may not require debriefings from a timeliness perspective. I suggest if you have any inkling of filing a protest, you call me the day you find out you're not the awardee, or in the competitive range, so that we can work through where to go. If we're in discussions, or if we're excluded from the competitive range, we're looking for unequal evaluations. We're looking for whether your proposal was evaluated fairly. We're looking for things as simple as, did they get your price right? And did they evaluate evaluation criteria properly? And now all of the same stuff again. Are we the incumbent? Is the cost of it worth it? What's the likelihood of success? What's the likelihood of a contract award? Do we have 20 other contracts with this agency, and protest them is going to make them mad, and this one contract isn't worth it? Is this our biggest contract and we need to protest even if the chances of success are low? We'll walk through all of those balancing acts. And as I say frequently to clients, the answer for one client is not necessarily the same as the answer for another. And so we work through it. We'll skip this for now because I know we're running low on time. After we file a protest, what happens? At GAO, which is where we're going to focus, the agency gets 30 days to file a response to our protest. That's going to include all relevant documents, meaning our proposal, the evaluation documents, It gets limited literally to relevant documents. The agency often will not, for example, provide the awardee's proposal if we're only challenging the evaluation of our proposal, or they'll only provide a small portion of the offeror's proposal, the awardee's proposal. If we're, for example, challenging past performance, we're not going to get their technical or cost proposal. After we get that report, which includes a legal document from the agency arguing why they're right, we get an opportunity to again respond based on the documents we see. If we learn any new protest grounds, we get to file those, and the cycle continues. All GAO protests are by statute required to be decided within 100 days. And even when the government shut down last time, they got every protest decided within 100 days. There could have been arguments to fix that if they needed to. The GAO's protests are all decided within 100 days. At court, the timeline varies. We get at court, the process typically looks like this. Within 2 weeks, we get what's called an administrative record, where we, the attorneys, get every document that's been associated with the decision. We then get 2 weeks to file a motion requesting that the court sustain the protest. The government gets a chance to respond to that. We get a chance to respond to that. The government gets a chance to respond to that. Then we go stand before a judge, and the judge tells us that we're right because we always are. And we move on with our lives, and they write a decision in our favor. Or obviously they don't always write a decision in our favor. But we get to go before court. The timing varies on a case-by-case basis there. Do we need to file for a preliminary injunction, or has the government agreed to automatically stay performance? What does that look like? Here was the question earlier, which is, we can also win. What happens when somebody else protests your award? I recommend in every situation that you are an awardee and somebody protests your award to intervene. I'm going to back up for a second first because I missed an important point here, which is documents may be protected. Know that when we talk about protesting, and this is going to be the case for protesting or intervening, know that I'm going to get access to a lot of documents, but you as the contractor likely will not. And the purpose is obvious, right? The purpose is the government doesn't want Boeing to get access to Lockheed Martin's proposal. They don't want IBM to get access to Apple's proposal. And so I get access to it under the firm commitment that I'm not going to share protected information with you. This becomes frustrating for all of you because I know a lot more than you do, but I also firmly believe it requires a tremendous amount of trust. If we win, we can intervene, which gives us all of the information we need to protect your rights in the process. I'm happy to answer more questions about it. I also have a separate bid protest intervention article that I wrote with my friend Matthew Keller years ago, which still holds perfectly true today. I'm happy to send it to Lindsay to pop in if she emails everybody these slides so that you can see it. But bid protest intervention, I think, is critical. I'll tell you that I'm currently working on a protest where somebody waited until after the decision was issued to try and intervene, because now they know information that had they intervened, they would have known sooner and been in a much better position to protect their interest. But because they didn't intervene, they didn't know, and they likely will lose all of the work that they had won. So it can be fairly significant. It's not necessarily a process that costs a lot of money. It can be narrowly tailored and geared as necessary. But having somebody be your eyes and ears, I think, is critical. Anytime you've worked hard and you've won work and somebody is challenging it, I think it's really critical that you intervene. I think we have a couple minutes left if anybody has any questions. I flew. I apologize for flying through.
Yeah.
But if anybody has any questions, please feel free to let me know.
What is the cost of a bid protest?
I hate that question, and I know we talked about it. The cost is, it really varies. And it depends on the issue. It's an important question to ask. Everybody asks it. It really depends on the issue or issues. It depends on the it depends on what venue you go to. It depends on whether we need to fight for an automatic stay. I think that a protest from start to finish can cost anywhere from 25,000 to 100,000 plus. When we get a particular protest and we understand what the issues are, I work with clients to, thank you, Ken. I work with clients to work through what the numbers are going to look like for them, how many attorneys we're going to need to work it. Is it a client that's done this 100 times that doesn't need hand holding, or is it a client that's doing it for the first time that does? Either of which is okay, some of which costs more than others. And we'll work through it on an individual basis.
Is there a downside to intervening in a bid protest?
None. There is no downside to intervening. There is only upside. You can help the government, right? If they want your help, you can help the government formulate ideas. You can protect your client's interests in ways that nobody else can. No downside. Other than cost, there is no downside.
And what do you look for when advising clients about whether to protest or not?
A lot of my objective when I speak with a client about protesting, aside from the obvious, hey, do we have a reasonable protest ground, is the impact to the business and the impact to whether or not we're going to get work. GAO and the court generally don't mandate awards be made to the protester. They generally, these are process protests. We're challenging to argue that the government did the process wrong. And so what I'm looking for is, if you're going to drop somewhere between $20,000 and $100,000, is the success going to be a contract for you, or are we not going to have success in getting to that end goal? Are we going to convince the government that they were wrong, but it is so clear that the government wants Karasov that they're just going to get to Karasov no matter what? I just advised a client yesterday to withdraw a protest because it was abundantly clear to me that even if we won, and I think we were right on our issues, they were not going to be next in line for award. They were going to be 6th, 7th, 8th down in the pecking order. And so they could have fought, and it would have been a good fight, and I would have felt really good from a legal perspective about what we were arguing. They were never going to get the work. And so they were going to spend the money to write something that was just not going to get them the result that it's a business. And so what I want to make sure we're doing is putting all of us in a great position to get you work and not just let me look good because I've won or lost a protest.
And again, I have to say, like, I think you're really, because I've referred clients and companies to you, organizations to you, I think you're really good at really looking at it from the company's perspective and not a personal perspective. So, you know, from an objective perspective. So anyway.
Thank you. I say that clients make more money than me because they take more risk than me, and often because I tell them not to give me money, which is a problem. But it's not about me. So I like learning other businesses and seeing how it goes. But I really appreciate that, Karen.
I just want to thank everyone for attending today. I will hand it over to Lindsay now.
Thank you, Karen and Daniel. Our Government Contractor Chat Zoom webinar series will be the third Wednesday of each month from 12 p.m. to 1 p.m. Eastern Time. Wednesday, March 20th, we will have Marie Jerabak, Vice President of Cost and Pricing Strategy at EOP Consulting, presenting Ushering in an Employer-Favored Labor Market in 2024. Wednesday, April 17th, we will have Jill Ryan, President and Federal Prime Program Manager at Gadfly, presenting Making a Mind Shift with CPARS. Wednesday, May 15th, we will have Diane Menser, Business Operation and Chief Operating Officer Advisor at Diane Integrates, presenting 6 under the radar KPIs are impacting the value of your company. To register for these webinars, you can scan the QR code on the screen now. Thank you for your time today. We hope to see you in March.